चलिए आजकल हम एडिटोरियल पढ़ते हैं द हिंदू से। ठीक है, आज है द कॉन्टोर्स ऑफ कॉन्स्टिट्यूशन मोरालिटी। ठीक है, आइए स्टार्ट करते हैं। आसान नहीं है, मुश्किल है, लेकिन अच्छे से इसको करेंगे। The relationship between morality and the law has fascinated, अभी टाइम हो रहा है 2:10। Fascinated many minds over the ages. Some have regarded the enforcement of morals as a function of law. The famous hard-tabling debate in the 1960s saw an unparalleled exposition by two fine legal minds on the benefit and pitfalls of using morality into the veins of the law. The 1916 also saw the House of Lords declaring in So versus DPP 1962 AC 220 that there existed a residual power to enforce the supreme and fundamental purpose of the law, with to conserve not only the safety and order but also the moral welfare of the state. The Supreme Court of India recognizes the relationship in P. Rathinam versus Union of India 1994, SCC 394, when it quoted with approved by the observation of Justice Frankfurter and Solby versus Walcom, that the law embodies a system of right based on the moral principle which comport with the deepest nation of the world. It's fair and right, it's just. In ancient times, there was no particular distinction between law and moral. There was the concept of drama which embraces concept of law and morality. The Tricurl, for just instance, has much emphasis on the virtue aram. This complex relationship entails that sometimes law leads morality, abolishing untouchability before societal acceptance, which did not happen. A law follow it so slow. Recognition of gender equality. The challenge is ensure that law remains just a representative of fundamental ethical imperatives, not merely majoritarian's opinion or transist popular sentiments. A resurgence of the concept. In recent times, there has been a resurgence of the concept of morality in the constitutional scheme of things. Under the umbrella term constitutional morality, what is the term? How does it empower court to look at the constitutional question? There are two. There are the two key issues. The term itself is not of recent vintage. In his book History of Greece, historian George Grote wrote the Greek found it necessary to protect their constitution by kindly passionate attachment which he termed constitutional morality. Grote observed a paramount relevance of the form of the constitution enforcing obedience to the authorities acting under the within those forms. It combined with the habit of open speech of the action subject only to find legal control and the unrestrained ensure of those very authorities as to all their public acts combined to with the perfect confidence in the bosom of every citizen amidst of the bitterness of party constance that the forms of the constitution will not be less scared in the eyes of his opponent than in his own. In the course of this fairly debate in the Constitutional Assembly, Dr. Bhim Rao Ambedkar invoked this passage to underscore the need for and elaborate the detailed administrative mechanism in the text of the constitution. He added the constitutional morality is not a natural sentiment, it has to be cultivated. We must realize that our people have to yet to learn it. Democracy in India is only a top dressing on an Indian soil which is essentially undemocratic, drawing a distinct drawing a distinction. It is now this carnival of constitutional morality may be termed as a rule of constitutional propriety conduct amongst constitutional functionaries. However, the question is whether breach of such rules could give rise to action in the court. Professor Dickey observed that constitutional law consisted of two elements. That first is the law of constitution, which is body of undoubted law relied upon and enforced by the court. The second is a set of rules consist, consisting of conventions, understanding, habitat of practices which regulate the conduct of several members of the state, but which are not enforced by the court, which in term as a convention of the constitutional or constitutional morality. Thus, Professor Dickey drew a clear distinction between constitutional morality and the law. In the positivist sense of the term, according to him, a bench of the constitutional morality or a convention of the constitution are not actionable in court, yet they they derive their binding force from the fact that a breach breach of constitutional morality or constitutional convention would almost immediately bring the offender into a conflict with the court and the law of the land. In the S.P. Gupta case, Justice Venkatar Venkatira pointed out a convention in the role of constitutional practice which is neither enacted by parliament as a formal legislation nor enforced by court. Yet, its violation is considered to be a serious breach of constitutional morality leading to grave political consequences to those who have indulged in the such violation. In India, Young Lawyer Association versus the state of Kerala 2018 Sabrimala case, and the Chief Justice of India CGI Deepak Misra held that the expression of public morality occurring in the Article 15 ought to be understood as being synonymous with constitutional morality. This position has since been doubted and the matter has now been referred to 9-judge bench. Expression has on again the considered in the Manoj Narula versus Union of India. In Narula, the Supreme Court was invited to read into Article 75 of Constitutional disqualification against the member of Legislative Assembly, member of Parliament who were facing charges for heinous or serious offence. The Chief Justice of India the Chief Justice of India observed the principle of constitutional morality basically means to go down to the norms of the constitutional and not act in a manner which would become a violative of the rule or law reflecting of action in a arbitrary manner. The passage is simple court appeal for paramount reversions to the form of the constitution. However, the court ultimately held that it was not possible to rewrite Article 75 by describing a dequalification which was plainly not there. If it went to further than to say that could legitimately expect the Prime Minister would not choose a person accused of heinous offence as a minister in the cabinet and concluded this is what are the constitution suggests that and that is the constitutional expectation from the Prime Minister. Rest has to be left to the wisdom of the Prime Minister. We say nothing more, nothing less. Instead, National Territory of Delhi versus Union of India, the court went further and held that constitutional morality did not mean more allegiance to the substantive substantive provision and the principles of constitutions. The court identified legal value and the consensual decision making amongst the state agency as faced faced of this concept. To this were added responsibility and duties that is imposed on those who held constitutional offence offices in Justice K.S. Putta Swamy versus the Union of India The requirement of constitutional morality required that the government not to act in a manner that violated the rule of law. By the same token, it was emphasis that is the requirement of the constitutional morality required the state from the acting in a manner that violated the order of the court. Their decision, these decisions so the constitutional morality encapsulate morality acceptable standard of the conduct of the constitutional actor in the constitutional sphere of things. A breach of the such standard may not but be actionable in the law courts. Breach of constitutional morality. Court breach a constitutional convention triggering the violation of the constitutional principle of a rule of law. It must be remembered that courts are not the sole areas where the breach of constitutional norms can be remedied. Such breaches may have consequences as well as, for instance, being held accountable on the floor of parliament or at the hand of the electorate. The remedy in an appropriate case is therefore always contextual. There is a two word I don't know the meaning of these two words. First is breach and second is remedy. Remedy, I know the meaning of remedy little bit, but I don't know exact meaning of remedy. The next paragraph of this editorial is a vital role to play. The road forward for India lies in the continually cultivating constitutional morality among citizens, lawmakers, and judges alike. It is a living ethos that will transform constitutional guarantees into tangible justice, fostering inclusion, protecting minorities, and ensuring equality in a rapidly changing society. As Bhimrao Ambedkar poignantly advised, constitutional morality is not inherited but must be nurtured and embraced. Its vitality is the difference between a constitution that is merely a document and one that is a vibrant, equitable reality for all Indian. It is only then that democracy can be vital ingredient and not a mere dog dressing on Indian soil. I have completed this passage from the Hindu. This is a editorial part. I have completed first editorial part, not second one. I will complete second editorial uh, in another video. I will upload in another video. Second editorial name is Winding Up the Clock of India Nepal Economic Time. Okay, let's finish this video. I hope you will enjoy. Thank you so much.